of supervising parole and probation, or parolees and probationers. His dad is a retired worker from DTE Energy. His parents have borrowed from their retirement in order to retain counsel on his behalf. Speaking to Mr. Smith's work background, he's obviously resigned from his job due to this case, but he has been consistently employed since his senior year of high school, working in various industries like food service, manufacturing, trucking, and hospitality. He is confident that he can become employed should he be released in this matter, and he does believe he has a lead on a case or on a job to become a janitor. I have had a chance to review the police report in this matter, Judge. I would note that there's no mention of any injury to the complaining witness or no mention of any medical treatment. And based on that police report, I've done a preliminary run of his sentencing guidelines, and assuming for the sake of this bond argument only, that if he were convicted of assault with intent to do great bodily harm and he were given points under OV3 for bodily injury requiring medical treatment, maximum points for psychological injury to the victim, and maximum points for exploitation of a vulnerable victim, his sentencing range would still be 0 to 17 months, meaning it would be an intermediate sanction since it's an under 18-month sanction. And as this court is well aware, jail is not an intermediate sanction. So that presumptively this would be a probation sentence.
I understand how sentencing works. Go ahead, get to your end of your argument.
Okay, concluding, Your Honor, I would note that there was 14 days between the arrest and the incident in this matter where there were no allegations of wrongdoing. Mr. Smith was proactive in looking out and getting a booked therapy appointment, which he would like to get back to. We'd be asking for a cash bond that Mr. Smith can afford because we do not believe he is a danger to the community or a flight risk. We'd ask for a $2,500 10% cash bond in this matter, Judge.
Response.
Your Honor, we originally requested a $75,000 cash as surety in this case, and we were given $75,000 with 10% privilege. This is a case that was completely captured on video. The defendant is a teacher at was a teacher at Ypsilanti High School. The victim in this case is a 14-year-old student. Here, the victim and the defendant appear to have gotten into a verbal argument. At one point, the defendant instructed the victim to do push-ups. The victim told the defendant that he was unable to do so because he had a wrist injury. And then at that point, the defendant got in the 14-year-old space and said, "That's some bitch ass shit." The defendant then followed the victim as he started to walk away. And at that point, he strangles him for several seconds with the sleeve of his sweatshirt. It was only when two teachers walked up and intervened that this concluded. The whole thing is on is on video. And aside from the physical acts of the defendant, what is extremely concerning is that in his own words, in his statement to law enforcement, when asked what happened, he said he had a headache and he snapped and he knew it wasn't right. So I'm significantly concerned based off of the nature of the physical acts, which were all caught on video, but also the defendant's own admissions here about what exactly happened.
May I have a brief rebuttal, Your Honor? Even with the series,
there was a 14-year-old, he was a teacher, and there was a strangulation.
Those are the allegations, Your Honor.
Yeah, go ahead with your response.
And even with the seriousness of these allegations, we fully recognize the seriousness. I think the guideline argument remains that this still is a presumptive probation. And I think to the danger of the community, I think the 14 days between between the incident and arrest where there was no court order in place, where there's no allegations of wrongdoing, speak to the danger of the community that Mr. Smith is. And I believe that that danger can be mitigated with reasonable terms of bonds, such as possibly a tether or a cash bond that he may afford, which we would ask for $2,500, 10%, Your Honor.
There's a $75,000, 10% bond.
I understand, Judge.
They didn't request that I raise it. I actually should raise it, given what I've heard. I will not. However, your motion for bond reduction is denied.
Your Honor, would you consider release if he was to live at his mother's house rather than by himself in Ypsilanti as a condition of bond?
And I thought I ordered something.
I was just asking if it would sway your decision at all, Your Honor.
No, when I'm done, I'm done.
Fair enough, Judge.
Thank you.
Thank you, Your Honor.
Violation of bond that we received. We would just ask that the sentencing be pushed out so my client can get back into compliance. As I said, I'm going to be walking her over to community corrections as soon as we're done here. And she is interested in resolving this case, Your Honor. She wants to enter a plea of 7411. I have the waiver here for the waiver of her exam.
So she wants to waive up and plead.
Yes, that's correct, Your Honor.
Well, how do I know that she's going to get in compliance with this? Because she wasn't telling me the truth when she came in.
Your Honor, my client was, to say it in the simplest way, she was terrified, Your Honor. She understands that, there's no excuse for her behavior. Like I said, she's admitting to the violation at this time.
And I do apologize.
Well, what is she admitting to? Because she, first of all, blamed the jail. Then she blamed other people for not getting there. So what's the true,
Your Honor, she's willing to take responsibility that it was on her to figure out what she needed to do. And she shouldn't have waited for somebody to send her paperwork. She should have gone over to the courthouse, gotten the paperwork herself, gotten everything she needed, went to community corrections. She does want to rectify the situation, Your Honor. We do want to fix this. If the court deems additional testing, my client is open to that as well. So we will leave it to the discretion of the court, Your Honor.
what do you do during the day?
I clean houses, Your Honor. I actually own a cleaning company, so. Yes, sir. I know.
You're gonna
I'm but one.
order, but
Helps, but
a new order. But we're gonna not do it.
This is a big moment. The defense is asking for a formal bond violation hearing instead of immediate punishment. That's a strategic move. It buys time and challenges the credibility of the alleged violation. But remember, this defendant already served jail time once for breaking conditions, so the judge is clearly not starting from zero trust. What do you think? Should previous violations weigh this heavily?
You understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
yes, Your Honor.
People also waive their rent.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the same.
This shift introduces an entirely new defendant and a new issue, a bond violation request. In legal terms, violating a bond can lead to jail time, new conditions, and even harsher terms later. Judges hear excuses constantly, so the credibility of the defendant is everything. Right here, the attorney is trying to rebuild trust, brick by brick.
Pretrial will be August 12th, 2024, 1:30, Judge Slay. Monday. You admitted to the violation of bond, and her bond will be continued as previously said. I'm going to enter a new order that she'll have to comply with.
Huge moment. The judge openly challenges her honesty, and that's devastating in court. Once a judge believes you've lied, every future word becomes a mountain to climb. Question to you watching. If someone lies once in court, should they still be offered leniency later?
I'm lying to myself, so I understand, Your Honor, and I
Well, I always tell people, I'll deal with the truth and we can deal with each other when it's that way. But if you lie to me,
yeah,
that's
difficult.
That's going to be the bigger problem.
I understand.
So the sentence on the violation, defendants to serve 5 days, Washington County Jail. Defendants remanded.
Okay.